Sure, I am.
All right. Let's go ahead and start. Good afternoon, everybody. My name is Hans Muller. I work with the PRC's Office of General Counsel, and I will be presiding over today's public comment hearing. We are here in the matter of case number 2000105 FM, which is the fire marshal proposed rulemaking. The commission is considering repealing and amending rules 1025-1, 1025-2, and 1025-5 of the NMAC. Specifically, they're considering changes regarding the inspection and testing of fire and smoke dampers in accordance with evolving National Fire Protection Association standards, provisions within the general provisions, including, among other things, definitions that are used in Part 5, provisions within the certificates of fitness, containing provisions establishing the methods of becoming certified to install, test, and inspect fire and smoke dampers, and other changes to modernize the rules. In compliance with the notice of proposed rulemakings that were posted, today's hearing is the public hearing regarding the proposed rulemaking. Just to set some standards, right now I have approximately 38 people signed up to make commentary. I will be going through those, calling the individuals. I have the list of those who have signed up. I will be calling those individuals by name. Because we have 38 people signed up and this is currently scheduled for 3 hours, what I am proposing is that everyone limit their initial comments to 3 minutes. And once we have made the first pass of comments, I will open the floor again if anyone wishes to make comments on comments that have been made. So I'll have a second opportunity for you to make remarks on what the previous people have said the second time. But in the interest of time and efficiency, I would ask that you limit your initial comments to 3 minutes. Just to give you an idea of some of the order that I will be going in. Give me 1 second here. I'm going to call on individuals from the State Fire Marshal's office first. Then I will reserve a time slot for Senator Stewart. After that, we will hear from individuals in the Regulation and Licensing Department, individuals associated with unions, then code and licensure entities, contracts, developers, and consultants. And there are a couple other individuals who have signed up as well. So bear with us. Like I said, there will be 38 individuals initially. I will take a break, probably give us a break at the hour 15-minute mark, hour and a half mark, just to give everyone a break. And then after, like I said, after we have gone through the initial commentary, I will open the floor back up for those who want to make further remarks on people's comments from the first round. So with that being said, everyone has the ability to mute or unmute yourself. So when I call on you, please remember to unmute yourself for your comments. And then I would ask that people stay muted just so we don't have a minimal amount of background noise while other people are talking. With that being said, let's begin from the State Fire Marshal's office. First name I have is David Black, counsel for the Fire Marshal. David, I'll yield the floor to you.
Thank you, Presiding Officer Muller. I'm David Black, and I represent I work for the legal division at the Public Regulation Commission, and my client in this case is the State Fire Marshal's Office. As you know, the order states that, or the initial order that was issued, that issued the notice of proposed rulemaking states that the hearing in decretal paragraph F as in Frank, the hearing will be held in order to receive oral comments only by those persons who did not file written comments or responses in any capacity. So technically, I'm not supposed to be able to make any comments because staff did file their initial comments and the response comments. However, I do have some typographical errors that I have noticed that I would like to provide orally so that it's part of the record if I can proceed.
Yes, thank you for that, David. You may proceed with it.
Thank you. I'm looking as to part 2, 10.25.2.7 A, B, and C. Each of those, for A and B, 10.25.27, 0.2.7a, remove initial caps from the spelled out, quote, National Institute for Engineering Technologies, because page 192 of the legislative drafting manual, which is applicable to all rulemakings, states that institutions or other bodies are not capitalized in a rule. Similarly, in 10.25.2.7 B, capital B, remove the initial caps from the spelled out, quote, Construction Industries Division, so that there are no capitals in any of those words for that same reason of the legislative drafting manual, page 192. For 10.25.2.7 C, the proper term used by the Construction Industries Division is, quote, qualifying ing party, not qualified party, and that change should be made as a typographical error. 10.25.2.9A4A, the phrase qualified party is changed to New Mexico NMCID qualifying party. So again, qualified party is changed to NMCID qualifying party to use the proper CID term, and for precision to identify the New Mexico Construction Industries Division in context there. Those same changes are made in typographical changes are made in 10.25.2.9A5A, 10.25.2.9A6A, 10.25.2.9A7A, 10.25.2.9A8A, and this is slightly different, 10.25.2A9. Finally, for that part, the change should be a typographical error to correct at 10.25.2.12C. Correct the typographical error in the second sentence that says currently beginning July 1, 2020, and that should be changed to beginning July 1, 2021 to reflect the correct date when the State Fire Marshal leaves the Public Regulation Commission and becomes part of the New Mexico Department of Homeland Security and Emergency Management. So those are all the changes for part 2. There's just one change to part 5 that I discovered, and that would be 10.25.5.16 G3 to change the language from, it currently says, quote, the fire protection system was not initiated by a licensed entity and certified journeyman, close quotes, changing that to say, quote, the fire protection system was not installed by a NM space CID licensed entity and a proper NM space CID qualifying party. And those are the only typographical changes that staff has at this point in time. Staff does have, as you know, presiding officer, where are they? Has identified interim Fire Marshal John Kondratik to make a statement, Raymond Torres to make a statement. They have also identified Lawrence Montoya and or Lee Ortiz to make a statement. And of course, our Chief of Staff, Jason Montoya, if he would like to make a statement. And with that, I'll pass.
Thank you, Attorney Black. Let's move along to John Kondratik. John, if you can unmute yourself.
Good afternoon, commissioners, senator, presiding officer, and guests. My name is John Kondratik. I'm with the State Fire Marshal's Office. I'm currently serving as the acting State Fire Marshal and also in the Deputy Fire Marshal over in fire investigations for the agency. To give a historical perspective in regards to this rulemaking process, the 2019 legislature directed the PRC and State Fire Marshal's Office to issue rules requiring the inspection and testing of fire and smoke dampers and smoke control systems. During this process, the Code Enforcement Bureau determined the need to establish and implement rules based on nationally accepted standards, not only for dampers, but also for fire alarms and fire sprinkler systems. The Code Enforcement Bureau developed these administrative rules as required in a comprehensive manner to address all aspects of code inspections in an effort to promote public safety and fire protection in all New Mexico public occupancies. As this process advanced, the Fire Marshal's Office encountered some issues regarding confliction with CID rules and authority to establish scope of work requirements for New Mexico fire protection system contractors. Our agency recognizes the work done by the authors of these proposed rules. We acknowledge that there is room for modification and further discussion if determined by the Commission, and are ready for additional collaboration with pertinent stakeholders if necessary. Today, speaking in support of the proposed rules, are staff of the Code Enforcement Bureau of the State Fire Marshal's Office, who will provide comment, as well as Mr. Chip Hollis with the National Institute for Certification in Engineering Technologies, or otherwise known as NICET. Mr. Hollis will discuss certifications for fire protection industry and the benefits of such certifications. These proposed rules have received support from the Fire Service to include the New Mexico Fire Chiefs Association. If approved, the State Fire Marshal's Office looks forward to working with our local fire officials and contractors in implementing these rules. The agency's ultimate goal in the formation of these rules is to develop fair, lawful, and consistent regulations in accordance with nationally accepted fire protection standards for the industry in an effort to promote safety and protect lives and properties from the devastating effects of fire. That's all I have, Mr. Presiding Officer.
Thank you, John. Appreciate your comments. We'll move to Lawrence Montoya from the State Fire Marshal's Office. Lawrence, if you can unmute yourself.
Hello, Mr. Presiding Officer. How are you, sir?
Good, thank you.
So our office was tasked with performing the modifications and the amending of the rules pursuant to 1025-1 and 1025-2 and 1025-5 of the New Mexico Administrative Code. And so in doing those changes, I can assure you that as a co-writer, the amended rules pertaining to the fire protection systems, their requirements, and all of the additional modifications were made in an effort to develop and maintain a fair and consistent and objective way to establish and maintain the standard across the industry, and ultimately to keep the public safe. There have been changes as a result with the requirements of the certificate of fitness. Our office maintains that under state statute, we've had the authority to maintain a certificate of fitness program, which not only recognizes the competency level of fire protection contractors, installers, but also ensures that they meet the minimum standards of the common practice within the industry. And we feel that the changes that were made are not excessive, they're not egregious, and will not only provide for a safer New Mexico, but also a more consistent and objective way for our office to ensure that every company working within the state of New Mexico is compliant and meets a minimum competency level. That's all I have.
Thank you, Mr. Montoya. Next for comment is Raymond Torres, the State Fire Marshal's Office. Raymond, unmute yourself.
Yes, can everybody hear me?
Yes, we can.
Okay, sorry about that. The New Mexico State Fire Marshal's Office has been in existence for over 36 years. It has been taking much pride in attempting to provide an essential service to the citizens of this great state. The Fire Code Enforcement Bureau is made up of individuals who are tasked with ensuring the safe and proper installation of fire protection systems, amongst other responsibilities. The changes that have been included within the proposed rules complies with the common practice, current CID adopted standards, and industry standards. The added definitions in the proposed rules are much needed and to clarify expectations with our office while maintaining a healthy working relationship as well with the other local AHJs. These changes will help the New Mexico State Fire Marshal's Office, local fire departments, fire protection contractors, fire protection installers, and most importantly, the citizens within this state of New Mexico. Thank you.
Thank you very much. Next for comment, we will have Lee Ortiz from the State Fire Marshal's Office. Lee, go ahead and unmute yourself.
Good afternoon, Presiding Officer. Can everyone hear me?
Yeah, speak up a little bit, Lee.
How's that?
That's better. Thank you.
Good afternoon, everyone. I'd just like to speak on as a co-writer for this proposed rulemaking. Let me go ahead and get my video going here. So I would just like to kind of elaborate a little more on what Lawrence Montoya had spoken about. And you know, it is our interpretation that this rule change gives us a beneficial advance when it comes to competency requirements for fire contractors throughout the state. We did our most diligent, we gave our most diligent effort in writing this document to be as objective as possible for all parties involved, all stakeholders. You know, we just are very passionate and very confident that this rule change will bring a great amount of progress to the fire industry in the state of New Mexico. Some of the clarifications we've made throughout the document will also aid us in internal procedures that have had questions throughout the years, specifically partnership agreements and a clear definition and a clear path forward when issues arise with municipalities throughout the state as well. That's pretty much all I have.
Thank you very much, Lee. Next and last person from the Fire Marshal's Office will be Jason Montoya, Chief of Staff for the PRC. Jason, if you can unmute yourself.
Good afternoon, Presiding Officer. How you doing, everybody? Good to see some familiar faces. Hopefully everybody's doing well and you're all staying and remaining healthy. I really don't have a lot to add. I'm going to enjoy the show and listen to comments made by everybody. I just want to recognize that you're spending some quality time with us. This is important to the legislature. It's obviously going to be important to the PRC and the industry. So I look forward to hearing from everybody. Thank you.
Thank you, Jason. Next up, I am aware that we have Senator Mimi Stewart. New Mexico Senator has signed up for commentary, and I'm going to allow her to make her comments at this time. Good afternoon, Senator.
Good afternoon, Mr. Mueller and everyone. Thank you for allowing all of us to comment on these important regulations. So I was the sponsor of Senate Bill 143 in 2019. That statute is what has triggered this rulemaking. The bill that was passed, the statute after the amendments and the agreements, is very clear and unambiguous. It's barely more than a page long. So subsection A requires that the PRC adopt rules requiring inspection and testing of smoke dampers and smoke control systems in accordance with National Fire Protection Association standards. Section B requires that the rules require that inspections be performed by either state or political subdivisions of the state with a fire and life safety enforcement program. Pretty sure that is what the fire marshals are talking about. Or another person possessing a fire life safety certification from a program accredited by the American National Standards Institute. So that's pretty much it. The bill does have one more section. In that same section B, it requires either the state or political subdivision with the fire life safety program or the fire life safety certificate or the person conducting the inspection or test shall submit findings of non-compliance to the owner of the public occupancy and to the state fire marshal. So that's all the statute says. Now it does require that PRC promulgates rules, but it does not give the PRC authority to license the inspectors or modify the certification level required by the statute. It just gives the PRC the authority to require that inspections be done and they be done by persons with the appropriate qualifications. And during the passage of this bill, we were presented with quite a lot of evidence that we need more certified people doing these inspections. This is fire, life, and safety that you all are talking about. And yet we saw multiple instances of buildings not being inspected with these fire life safety dampers. I think the proposed regulations, and I have not read them in full, so there could be some errors in what I'm saying. It seems that it encroaches on the authority of the Construction Industries Division in regulations and licensing. So our own state fire marshal wanted to asked to terminate the proceedings because the state fire marshal did not consider the ramifications of enacting additional qualifications for licensed contractors. It's created a possible conflict with the CID rules. So as I've noted, the 2019 statute does no way enlarges the authority of the PRC to determine the qualifications of the inspectors or the content of the inspections. So I think one of the issues here is that the proposed regulations allows for this certificate of fitness that we've been talking about to work on fire and smoke dampers for persons that do not have what the statute requires. And that is a fire life safety certification from a program accredited by the American National Standards Institute. I believe the bill was very simple and very direct and unambiguous. And I'm hoping that we can get back to the language of the bill to ensure that we have solid, good inspection programs. Thank you so much, Mr. Mueller, and for everyone listening.
Thank you, Senator, for those comments. Next, I would go to individuals from the Regulation and Licensing Department. I have Superintendent Marguerite Salazar.
Yes. Can you hear me?
Yes, I can. Go ahead, Marguerite.
Okay, great. Well, thank you, Mr. Presiding Officer, members of the commission, and Senator for allowing me to testify this afternoon. My name is Marguerite Salazar, and I'm the Superintendent of Regulation and Licensing. We recognize that rulemaking can bring various concerns from the public, and yet the state agencies that we really have a legal responsibility to carry out the mandates of the legislature. Like you, we recognize that the hearing process is a huge responsibility to create, first of all, a record, and then the opportunity to hear comments that could impact your ultimate decision making. With that in mind, we are testifying to let you know that we have heard from many, many different constituents. We've received emails, calls, people who are very concerned that the rules that are as they are presented will negatively impact the construction industry, the economy, and really don't impact public safety. Specifically, we will explain our interpretation of how the current and proposed rules go beyond what we believe are the PRC statutory authority and conflict with the Construction Industries Commission's legal authorities and rules adopted by the same. The New Mexico Commercial Building Codes, existing building codes, and fire codes all acknowledge the necessity of collaboration of these codes, as well as plumbing codes, mechanical codes, and electrical codes. It is our opinion that it is in the best interest of the residents of New Mexico as it relates to the health and property safety for other state agencies and the industry that we work in coordination to adopt rules that recognize the interaction between all of these codes. Now with that, I'm going to turn it over to our General Counsel, Kevin Graham, who will be more specific in talking about our real concerns and comments. Thank you.
Thank you. Council Graham, go ahead.
Good afternoon, Mr. Presiding Officer, Commissioners, Senator, colleagues, and all participants who made this call. I am Kevin Graham. I'm the Acting General Counsel for RLD, and I would like to address some of the things first that RLD recognizes about rulemaking in this situation. State Statute 59A-52-15.1 certainly does grant authority to the PRC to issue rules requiring inspection and testing of fire and smoke dampers and smoke control systems in accordance with the National Fire Protection Association standards for buildings specified within the statute section. Now, we further recognize that these rules to be adopted by the PRC must require that such inspection and testing be conducted by the state or political subdivision of the state with a fire and safety enforcement program, or another person possessing a fire life safety certification from a program accredited by the American National Standards Institute. This is exactly what Senator Stewart was explaining the bill did. It's pretty simple. It talks about inspection and testing of fire and safety enforcement programs and fire safety smoke dampers and smoke control systems. However, we are testifying today because the RLD clearly believes, and that our Construction Industries Division, CID, that the current proposed rules under consideration by the PRC extend beyond inspection and testing to installation. In fact, the word installation is used numerous times throughout the rules. And I think your staff would tell you that that word installation was in the rules prior to this, probably from around 2007. The problem is this statute, 15.1, and the preceding statute, 59A-52-15, never gave authority for the Fire Marshal's Office to be issuing rules regarding installation of equipment. And those are the key distinctions here: installation versus inspection and testing. No one's challenging the authority for you to issue rules regarding inspection and testing. We do, however, see great conflict when you step into rules that deal with installation. Specifically, the current and proposed rules as they are worded in the drafts expand the PRC and State Fire Marshal's authority to require contractors and journeymen to obtain additional certifications for installation, which they are already authorized to perform through the licensing and certification requirements of CID. Now, one of the key purposes in formation of CID under the Construction Industries Licensing Act is to license contractors for construction projects and installation. That is already done and assigned to the authority of the CID under the law. The installation of fire and smoke dampers and fire control systems are authorized by the RLD and CID licensed entities and division certified journeymen in compliance with the New Mexico Mechanical Code as part of the heating, ventilation, and air conditioning system buildings or construction projects. So again, we're talking about the difference between installation of equipment versus the inspection and certification of equipment. We are further concerned that the proposed rules do not address the specific requirements of the statute as to inspection and testing and are not limited to fire and smoke dampers and fire control systems. The rules as worded would create this new certification for the people who are out there doing the work, doing the installations, not the equipment itself, which is under your jurisdiction, but the people who do the work to install it. You're essentially attempting to create a second licensing system for the people who would be installing this equipment. And that's not authorized under the law. Finally, at section 59A-52-15.1 requires that the inspection or testing be completed by the state or political subdivision. And if not conducted by the state or political subdivision, it must be by persons possessing a fire life safety certification from a program, quote, accredited by the American National Standards Institute, ANSI. If you look at the proposed rules, the rules required additional certification from the National Institute for Certification in Engineering Technologies, or NICET, it is often called NICET. We have received verification after inquiring from ANSI, the American National Standards Institute, that NICET is not accredited with ANSI. So requiring in the rule that someone be certified under NICET does not meet the statutory requirement for what is required for certification under ANSI. So that has to be corrected. The rules as currently written and under consideration will have a negative impact on the construction industry and the economy while not increasing public safety. There are errors that need to be addressed, and the rules certainly took notice of the comments from acting State Fire Marshal Kondratik, who recognized that there were issues in the drafts of the rules that may need to be worked out with CID, and his offer to work with us and to address those issues. We respect and appreciate that. And we certainly hope the PRC gives us the opportunity to do that before rules get enacted that are going to put us all in a position of conflicts in law between different state agencies, but also conflicts in law that may result in legal action that can invalidate rules entirely and have unintended consequences. The RLD staff are available to meet with and collaborate where our authorizing statutes are closely related to these issues of public safety. We respect the PRC and we certainly respect the State Fire Marshal and their desire to see the safety and soundness of systems for protection of our people. We want to work with you and come up with better rules that don't create these conflicts, and look forward to that opportunity. Thank you.
Thank you, Mr. Graham. Next, going to move on to individuals associated with unions. Isaiah Zemke from Smart Local Union 49. Isaiah, go ahead and unmute.
Yes, hello, presiding officer. Currently, these rules do not fulfill the requirements of the statute as rulemaking. By limiting the statute to inspection and testing only, there was a legislative recognition that fire and smoke dampers and smoke control systems are installed through New Mexico Mechanical Code as part of the heating, ventilating, air conditioning, HVAC systems. The rules cannot exceed the authority provided in the statute. The proposed rules require that contractors, journeymen, and inspectors both have a CID license and a NICET certification. There was no reference to creating any rules as to persons installing such systems as the legislature acknowledged under the CILA, Construction Industries Licensing Act, which establishes all requirements for licensing of contractors and certification of qualifying parties and journeymen who install these types of systems. The PRC recognized this by deleting the provision in the International Fire Code for the construction permit required pursuant to the IFC 105.7.14 for smoke control or smoke exhaust systems. The accreditation process, the statute specifically required that a person possessing fire life safety certification in order to conduct the inspection and testing must be from an ANSI accredited program. Accreditation was specifically included to be the legislative mandatory requirement due to the competence requirements for personal certification bodies and the importance of legislature saw in requiring such knowledge for a third party wishing to conduct the inspection and testing of fire and smoke dampers and fire control systems. In a conversation with Vijay Krishna, the Senior Director of Credentialing Accreditation Program of the American National Standards Institute, she revealed that NICET is not accredited by ANSI, the American National Standards Institute. These are not a business-friendly rules. They will cripple a lot of contractors throughout the state and furthermore hurt journeymen and inspectors. We are asking to terminate these rules and sit down with industry and all the interested parties here and get these rules right, so that way we can protect the citizens of New Mexico. Thank you.
Thank you, Isaiah. Next, I have Justin Cheney, IAFF Local 244. Justin, go ahead and unmute.
All right, thank you, Mr. Mueller. I would also like to thank Senator Stewart for her leadership on Senate Bill 143. Like you said, my name is Justin Cheney. I'm president of the IAFF Local 244, representing Albuquerque and Bernalillo County firefighters. We stand in opposition to the proposed rulemaking because it does not comply with the signed legislation of SB 143. SB 143's purpose was for inspections of fire and smoke dampers and smoke control systems with a fire life safety certification from a program accredited by American National Standards Institute. As first responders, my membership understand how important fire life safety is when it comes to inspections of fire safety systems like automatic fire suppression systems, fire alarms, and fire extinguishers that are all designed to work when a fire has started in a building to protect the safety of the public and the first responders. As I read through the rulemaking, the PRC is overstepping its authority to license the inspectors or to modify the certification level required by the statute. I helped lobby for SB 143. Its intent gives the PRC the authority to require that the inspections be done and that they be done by persons with the appropriate qualifications. We need to terminate this rulemaking immediately. I thank you, Mr. Mueller.
Thank you, Mr. Cheney. Next, I have Courtney Eichhorst with UA Local Union 412. Courtney, go ahead.
Good afternoon, Mr. Mueller. Good afternoon, everyone else. My name is Courtney Eichhorst, and I'm the business manager for UA Local 412 Plumbers and Pipe Fitters in the great state of New Mexico. And this doesn't necessarily affect my membership as much as it affects some of the other memberships and some of the other people around the state. But what I'm seeing is what's proposed in front of us is going to require licensing that nobody in the state has. There are more jobs coming to New Mexico now than most of you are aware. There's more work in New Mexico now that is having a hard time even to be inspected the way it stands. From WIP project down in Carlsbad all the way up to Farmington, there's projects happening every single day that needs inspection. And to impose more rules like the electronically actuated fire and smoke damper monitored by a fire alarm system, the person would have to have a valid MM98 or MM3, a valid ES3, and a valid NICET level 2 certification. I don't think there's a single person in the state that has all three right now. So I understand trying to make New Mexico safer. I want to make New Mexico safer for everyone here. I want to make sure that my kids who go to public schools in New Mexico are safe. That's one of my biggest challenges in the world, is being safe, but being realistic at the same time. To continue building the way we are in New Mexico right now, and to continue the growth of our economy, and to encourage people to build in New Mexico, we need to be realistic. And I don't think that this rulemaking is realistic. I think we need to terminate it and come to the table, and we can come up with some kind of solution, but this is not the answer to anything. So with that, I'd just like to say, please, let's terminate this and come back to the drawing table and figure out what we can do. Thank you all.
Thank you. Next, I have Dan Bombulis. Pardon me if I mispronounced that, Dan, from Local Union 669. Go ahead.
Good afternoon, everybody. Thank you for hosting this PRC meeting today, and thank you for diligently being concerned about the life safety systems in New Mexico. My name is Daniel Bambulis. I'm a representative of the Fire Sprinkler Fitters Local Union 669. I'd like to thank you guys for giving me the opportunity to speak at this PRC meeting, and also being diligent and doing your part to ensure we have responsible contractors as well as qualified tradesmen working on the jobs. As a sprinkler fitter, I'm always in favor of raising the standard of fire protection and improving life safety standards. Many states already have the requirement of NICET certifications in order to perform inspecting and testing of fire protection systems. We believe it's important to have certified licensed journeymen working on life safety systems. However, with the proposal of this current language requirement of the water-based system layout, we as a Fire Sprinkler Fitters Association believe it's going to be hard to obtain that NICET certification solely based on the requirements of the design experience in order to meet the water-based system layout NICET. While we fully support NICET and would love to recommend or work with the State Fire Marshal's office to amend the language to benefit fire sprinkler fitters as well as other tradesmen in the state of New Mexico, we would recommend changing that language to water-based system inspecting and testing, or also recommend additional language to allow additional certifications such as ASSE 15,000, the UA Star Card, or a journeyman certified tradesman with completion of an approved apprenticeship program, along with state licensing. We would love to sit down with you to create a stronger, safer New Mexico. We thank you guys for your time and your efforts. We hope to get the opportunity to work with you in the future. Again, we do believe in a stronger, safer New Mexico, and would like to ensure we have qualified tradesmen working on all jobs. However, with the current language, we are opposed to this proposal. Thank you.
Thank you very much. Next, I have Richard Gessner from Local Union 669. Rich, go ahead and unmute.
Thank you, Mr. Presiding Officer. Thanks, everyone, for the opportunity to speak. I'd just like to echo what my friend Daniel Bambulis has said. Local 669 is all about training, installing these systems right, and also inspecting these systems right. But we stand opposed to the way that the language is written. We'd like to get to the table and come out with some sensible language for everyone involved to keep New Mexico safe. That's all I've got.
I get a spelling of your last name.
Gessner.
Thank you.
Thank you. Thank you, everyone.
Thank you. Next, I'd like to move on to people who are signed up from code and licensure entities. Stephen Rinaldi from the New Mexico Association of Public Safety Officials. Stephen, if you are available, please unmute.
Thank you, Mr. Presiding Officer. I did have one question. Could you confirm how many commissioners are currently present in the meeting?
Right now, I do not believe there is a commissioner present.
And that leaves me with some concern because we have so much testimony that's coming forward from all these individuals and organizations that's not actually being heard by the commissioners. Hopefully it's being recorded that they could listen to it.
It is.
And it could be taken into account with regards to their decision on regarding this rulemaking process. Again, my name is Stephen Rinaldi. I represent the Northern New Mexico Association of Public Safety Officials, which is an ICC chapter, the International Code Council chapter for the Northern New Mexico. There's also a central and a southern chapter. Together, those three chapters make up the New Mexico Council of Code Officials, which I also serve as a board member on. Today, I'm representing all of our members with regards to the information that's contained within this rulemaking. We oppose this process moving forward for a lot of reasons. And let me clarify also that those associations are made up of local building officials and local fire officials throughout the state of New Mexico. One of the things that really has me concerned and a lot of our members is that this rulemaking is somewhat of a Trojan horse in that, particularly with regards to fire departments and fire marshals' offices, because of the section that's located within it that talks about the partnership agreements. Historically, nowhere with the state fire marshal has this particular partnership agreement been documented. It has been that they have had agreements signed with some local jurisdictions previously, but there's nowhere in a rulemaking process or state legislature mandate that any type of agreement is required for a local municipality to sign an agreement with the state fire marshal's office in order to be able to perform their duties with regards to fire and life safety in their communities. The wording within this, the rulemaking with regards to the definition of a partnership agreement, as well as the stipulation that only a municipality or a local jurisdiction that has an agreement would be able to enforce such rules. So with that particular portion in place, we highly protest the forward movement of this rulemaking process. On top of it, with the conflict between the State Fire Marshal's Office and the Construction Industries Division with regards to the situation over the licensing, as well as the NICET requirements. If you look in NFPA 72, it does not specify, particularly within the code body itself, the mention of NICET. It does mention it in the annex, but it also mentions a couple other organizations that have certification processes. With regards to that, and as mentioned by Mr. Graham previously as well, the NICET is not accredited through the other program that is state mandated. So with regards to the issues that are going to be presented here today, and that so many others have spoke about, and I'm sure that others will, with regards to our membership, we oppose this rulemaking process, and we ask that the termination and order that was originally considered previously be brought back and end this process for the betterment of the code making process and rulemaking process within New Mexico. The reasoning behind that is that we feel that additional time needs to be spent on this, and that the State Fire Marshal's Office, as well as the Construction Industries Division, the locals that have spoke here today, as well as other organizations that are dealing directly with these processes in the field, be involved a little bit more, rather than just having a couple people in a back room write up some information and start moving it forward. We would prefer that everyone that has a stakeholding interest in this process be involved in the process, particularly with the PRC making a rule at this point in time, and with the State Fire Marshal's Office transitioning over to the Department of Homeland Security. It feels like this has been kind of a rushed process, and we would prefer that a little bit more time and be taken on this, and that we be a little bit more prudent before we push things forward. Thank you.
Thank you. Signed up next is Perry Valdez, New Mexico Board of Licensure for Professional Engineers and Professional Surveyors. Perry, go ahead and unmute.
Thank you very much for allowing us to speak here at this rule hearing. Essentially, the Board of Licensure for Professional Engineers and Surveyors, I, as the Executive Director, wish to speak regarding some of the rule changes that were made, or that are being proposed, excuse me. One of the incidences that came up was that there was a recommendation by someone in the public that they should remove the requirement for engineers to sign off on shop drawings. We, as the Engineering and Surveying Board, feel that this would be an error. So the Fire Marshal's Office, State Fire Marshal's Office, take this under consideration, because removing the seal requirements of a licensed professional engineer to sign off on these plans would be contrary to safeguarding the life, health, and property of the public. In addition, removing that language would also place anyone who is NICET certified and signing off on these drawings would be in violation of our Engineering and Surveying Practice Act. And so we would oppose that change if the state fire marshals were to consider it. And with that, I would like to pass off also to a couple of our board members. We have a couple of our board members here, and I just wanted to let them also have a moment to speak on this as well. I have Mr. Ronald Bohannon and also Mr. Paul Brasher. So if one of them would like to speak, I will yield my time.
Thank you, Perry. I'll go. This is Paul Brasher, Mr. Presiding Chair. This is, I'm the Chair of the Board of Licensure for Professional Engineers, Professional Surveyors for New Mexico here. And we have reviewed the red line version of the proposed repeal and replacement rule for 1025.5 of NMAC here. And we would like to remind anybody who is listening, anybody who is interested in this, that, you know, anytime that we would really oppose and warn against removing any reference to professional engineering in the preparation of drawings as currently required. Now, anytime somebody makes some engineering calculations, they prepare engineered plans, they're practicing engineering. And so anybody that is preparing plans for construction without a professional engineer stamp on them will be working in a manner tantamount to providing engineering. And the person doing that will be considered in violation of the Engineering Practice Act and subject to fines and some enforcement. So what we strongly urge is that no references to professional engineering be removed from the red line version. Now, I noticed that in the red line version, it is 25 at 1025.52 paragraph C. There's an entire paragraph there. It seems to be planned to be stricken, which does reference the Board of Licensure for Professional Engineers and Surveyors, and we would like to we'd like to see that paragraph not be stricken because it makes a valid reference to licensed engineers. So plans need to be prepared with a professional engineer's stamp on them. And that's pretty much how we feel. Let me ask my colleague, Mr. Ron Bohannon, if he's got any comments to make on this, if you would, Mr. Presiding Officer.
Mr. Hearing Officer Mueller, Ron Bohannon, I am the president of the Professional Engineers Subcommittee of the Board of Licensure for Professional Engineers and Surveyors, and one of 3 hearing officers for the board. And so we actively pursue anybody who is practicing engineering without a license. And so what we're worried about in this period of design build, where you're starting to see a lot of blurring of the lines between professionals and installers, that people will assume the way it's written that they do not need a professional license to stamp engineered drawings. Everybody's intent is for life safety and public welfare. That is ours, as well as what the PRC is doing and everybody else. So I reiterate what Mr. Brasher and Mr. Valdez has, and strongly suggest that you don't take that out, so that people are not lured into the false pretense that they can go ahead and submit drawings that aren't stamped and sealed by a licensed professional. Thank you.
Thank you. Signed up for comment next, I have Chip Hollis from the National Institute for Certification in Engineering Technologies. Chip, go ahead and unmute yourself.
All right, can you hear me?
Yes, I can.
Good afternoon. My name is Chip Hollis. I'm the Senior Director for Credentialing and Administration at NICET. I appreciate the opportunity to provide some information about NICET to the Commission. NICET is a nonprofit organization founded by the National Society of Professional Engineers in 1961. NICET is a global leader in providing recognition of qualified technology professionals who can reliably apply requisite principles and practices for the benefit and safety of the public. Its mission is to provide an independent evaluation of technical knowledge and skills and experience among those working in the fields of engineering technology and define and support career paths for engineering technologists and related disciplines, and ensure the recognition of continued professional development of certified individuals. Since its founding, over 155,000 technicians and technologists have met NICET's rigorous certification criteria, and that number continues to grow as more employers and state, local, and federal governments rely on NICET certification to measure the qualification of their workforce. NICET's professional certification is a key component to ensuring a qualified workforce for the safety of the public. Professional certification provides a measure of knowledge and skill for the individuals and distinguishes the qualified from the not yet qualified. The key features that distinguish NICET as professional certification include third-party independence. Individual certification decisions are not influenced by membership bodies, industry associations, manufacturers, contractors, or government agencies. There's a career track component. NICET's career track features up to 4 levels of progression in knowledge, experience, and performance. Candidates and employers use the levels to map career paths and incentives. Agencies and specifiers use the levels to ensure proper qualification for defined roles. There are multifaceted certification requirements. Knowledge is achieved by passing an exam or exams. Experience documentation is compared to an industry set minimum standard. Candidates must demonstrate an ability to meet a set of industry determined performance measures. Levels 3 and 4 require a personal recommendation from a qualified individual who can attest to the technical quality, responsibility, and ethics demonstrated by the candidate. Level 4 requires the candidate to submit a write-up that describes their lead role in a project demonstrating senior level engineering technician capabilities and responsibilities. There's a recertification requirements that require every 3 years an accumulation of 90 continuing professional development points. All candidates sign a code of ethics and must agree to abide by. We have suspension and revocation of certification. So if these code of ethics are violated, or if there's other problems, we can suspend or revoke certification after a due process. We are vendor neutral. NICET certifications are not based on any particular manufacturer's equipment or tools. There's a consensus to the program development. Exams, work experience, and performance requirements are developed by working technicians, engineers, authorities having jurisdiction, and other stakeholder groups. Training and education is vital to developing a qualified workforce. Training can come from a variety of sources, from on the job to formal degree programs. Any training that teaches industry best practices will help candidates prepare for NICET certification. NICET intentionally does not provide training to avoid any implication of teaching to the test. NICET's fire protection certification were designed for engineering technicians working in the fire protection industry who engage in one or more or a combination of the following activities related to fire alarm systems, water-based suppression systems, and special hazard systems. This includes layout, equipment selection, installation, acceptance testing, system troubleshooting, system maintenance and servicing, inspection and testing, and technical sales. In the US, there are over 30,000 individuals certified in NICET fire protection. Our exams are administered on computers at Pearson VUE testing centers. Candidates may schedule as early as next day, have flexible dates and appointment times, and receive results immediately after completing the exam. Successful certification candidates receive a certificate, wallet card, and approval letter by mail. The NICET website provides a lookup feature to verify active certification holders. NICET certification programs are developed in accordance with the following industry standards. And as we talk about ANSI accreditation, it's really to the ANSI 17024 standard for personal certification. And everyone is correct, NICET does not have that certification. And we are seeking the ANSI version of that accreditation currently. The standards for education, other standards that we use are the standards for education and psychological testing, NCCA standard for the accreditation of certification programs, and the principles of fairness, an examining guide for credentialing bodies. Our efforts incorporate the overarching concepts of fairness, which means no bias, validity, covers the right material, reliability, you get the same results on multiple attempts, and legal defensibility. There are 10 phases of the NICET's program development process, with the practice analysis, industry validation, test design, question writing, item editing, SME review, form development, cut score, development of work experience, publishing the final exams, and ongoing review. Each phase is carried out by teams of industry experts to ensure the content is comprehensive and that the certified individuals meet an industry accepted measure of knowledge, experience, and performance for the benefit and public health, safety, and welfare. Rigorous standards for NICET certification and NICET's long positive track record of successful certification are why we welcome NICET certification's inclusion in these rules. Thank you for your time today, and I look forward to answering any questions.
Thank you, Chip. Next for commentary, I have Michael Arellano from the Los Alamos County Chief Building Official. Michael, if you're available, go ahead and unmute yourself.
Presiding Officer Mueller, hope you can hear me.
Yes, I can.
My name is Michael Arellano. I am the Chief Building Official for Los Alamos. I've been building official for a lot of other municipalities in other states and in this state. I believe this will conflict with the mechanical contractors that are already licensed through CID. The rule change itself will conflict with CID. There's going to be negative impact to construction and CID. Installation of the equipment, again, is the purview of CID. There are several accreditation programs out there. We don't have to limit it to one. And in closing, I oppose this going forward and support CID in opposition. Thank you.
Thank you, Michael. Next, I have Michael Bodelson, excuse me, from the New Mexico Board of Examiners for Architects. Michael?
On?
Yes.
This is Commissioner Espinosa. I was told you couldn't hear me, and I was also told I couldn't speak, so I thought I would do a test.
Okay, thank you for joining us, Commissioner Espinosa.
Thank you.
All right, Michael, I'm going to ask you to unmute yourself here. Otherwise, I can come back to you.
Okay, can you hear me now?
I can, Michael.
Okay, thank you. I'm sorry about that. Yeah, Michael Bodelson, Board Chairman for the New Mexico Board of Examiners for Architects. I'm speaking today on behalf of the board in support of the position that CID has taken regarding the proposed rule change. We're in agreement with CID. We are charged, just as the rest of you are, with life, health, safety of the public. Our concern primarily is that the appropriate location for this type of information is suited for, and I think directed by the legislature to CID. Our concern, in addition to that, is that this is creating, the potential for some confusion, conflicts that some people have noted as well. Anytime that occurs, I think someone, like say an architectural professional, can tell you that with all of the diverse systems that contribute to fire protection in a building, that there's potential for errors. Anytime those errors occur, the negative things are impacted for people who occupy those buildings. I don't want to take up too much time here, but we are speaking in support of the position that regulation and licensing, specifically CID, has taken, and we would also support the position of the Board of Engineers. If this rule is furthered, then the specification for requirements for licensed engineers should be retained. And that's the extent of our comment. And thank you for your time today.
Great. Thank you, Michael. Next, I will have to, on my list is a representative from the New Mexico Fire Chiefs. I do not have a specific notation as to who would be speaking on behalf of the New Mexico Fire Chiefs. If that is present, go ahead.
Yeah, this is Adolf Zubia. I'm a retired fire chief, having served as a past president and also past president of the Fire Marshal Association many years ago. I was contacted today based on some difficulties the chiefs had in being able to get on this call. So I told them I'd be happy to represent them. I'm going to read most of the resolution for the record, and then at the end make some comments regarding my perspective. Whereas the New Mexico Fire Chiefs Association is a subsection of the New Mexico Municipal League, whose membership is comprised of
slow down just a little bit, Adolf. I'll just for purposes of our court reporter. Thank you.
Okay, I just wanted to make sure I didn't violate your time requirements.
I'll give you, since I know you're speaking on behalf of the fire chiefs, I'll give you additional time for your comments.
Okay, then thank you. I appreciate that. I'll start with the second whereas, so I apologize for the person that was trying to take my testimony. Whereas the New Mexico Fire Chiefs Association is an organization created with the purpose of cooperating with other organizations to promote programs that further the goals and objectives of the fire service within the state of New Mexico. And whereas the New Mexico Fire Chiefs Association recognizes that the New Mexico State Fire Marshal's Office has the statutory authority to formulate, adopt, and promulgate and amend or revise regulations for fire prevention and safe conduct of the use of the public occupancies. And whereas the Public Regulatory Commission shall issue rules requiring the inspection and testing of fire and smoke dampers excuse me, and smoke control systems in accordance with National Fire Protection Association standards in places of assembly, educational occupancies, institutional occupancies, residential occupancies consisting of 4 or more family units, mercantile occupancies, office occupancies, industrial occupancies, storage occupancies, and miscellaneous structures consisting of towers and underground structures and windowless buildings in all buildings owned or occupied by the state or any political subdivision thereof, or by the municipal government. And whereas the Public Regulations Commission rules change proposal will be in effect until June 30th, 2021, and then effective on July 1, 2021, whereas the State Fire Marshal itself is substituted as the issuing agency for the rule change as expressed provided by the 2020 statutory law change in the New Mexico State Fire Marshal statute. And whereas the New Mexico Fire Chiefs Association supports the proposed rule change, which will strengthen the existing process in terms promoting life safety for all occupancies. Now, therefore, be it resolved that the New Mexico Fire Chiefs Association unanimously support the New Mexico Public Regulations Commission's proposed rule changes pertaining to 1021-1 general provisions, 1025-2, certificate of fitness, and 1025.5, fire prevention and public occupancies of the New Mexico Administrative Code. Passed, approved, adopted on the 9th day of October 2020. Just for your information, the fire chiefs represent, I think, 106 municipalities in the state of New Mexico. Now for my personal comments, again, my name is Adolf Zubia. I work for A to Z Code Consulting. I retired here as fire chief a number of years ago. I've been a state fire marshal in other states in this country. I've participated significantly in the code development process. Some of you in attendance, I know me from the International Code Council. I served as their past president. Let me tell you a couple of things. In reading the proposed rule change, I support the rule change because there's significant provisions on there that should have been amended in the New Mexico statutes for the fire marshal's office for a number of decades. Having dealt with that office since 1992, there are significant positive changes in the rulemaking process that's currently taking place. I truly appreciate some of the content and testimony that I just witnessed here for the last hour or so. There was some enlightenment that was provided to me that's given me a slightly different perspective. Regardless, I appreciate Fire Marshal Kondratik's initial comments saying that maybe this might need some tweaking, and I can tell you from the perspective that I heard that it definitely does, but I can tell you that the intentions of the Fire Marshal's office were not motivated by other interests other than just the public safety and public good on some issues that have been affecting the fire service and the constituencies in the state of New Mexico, based not by just what they do, but it's been my experience that there are significant gaps in some of the issues that were out there regarding certification, training, licensure, and oversight regarding people working on fire protection systems that really scare me and have scared me for a number of years. I appreciate the actions that have been taken by the Fire Marshal's office, and I believe regardless of what happens going forward, my hope is that this document is not in any way, shape, or form scrapped, but is used to amend and move forward in a manner that's going to be in the best interest of the public safety as a whole. So with that, again, I was and am speaking in support of the document in case there was some confusing testimony on my part. Thanks for the opportunity, Presiding Officer.
Thank you. That concludes the entities. I have the personnel signed up under code and licensure entities. The next grouping will be people associated with contractors, developers, consultants, and lobbying groups. I think what I'm going to do is I'm going to hear from the first two individuals, then we'll probably take a 10-minute break just so everyone can stretch and get a drink of water, whatever they need to do. First on the list, I have Lance Hunter from Microtech LLC. Lance, if you can go ahead and unmute yourself.
I'm unmuted. Thank you. Can you hear me?
I can, Lance. Thank you.
Okay. My name is Lance Hunter. I've been a fire alarm contractor in the state of New Mexico for 35 years. Been involved with NICET for 24 years. I'm a proponent of NICET. I think it's brought a standard to the state of New Mexico. And my group is in agreement with the state fire marshal's rulemaking. We think it's going to bring added benefit to a level of professionalism in the state of New Mexico, and we agree with it. That's about all I have to say.
All right. Thank you very much, Lance. Appreciate your comments.
You're welcome.
Next, I have Rhonda Gilliland from MCA of New Mexico. Rhonda, are you available?
Yes, I am. Thank you, Presiding Officer Mueller. I need to leave my camera off because my bandwidth is low. I would like to thank Senator Mimi Stewart for all of her hard work in this initiative. The proposed rules create an additional requirement for licenses and certificates above the legal requirements that the Construction Industries Division is mandated by the legislature through the Construction Industries Licensing Act to establish for contractors and journeymen to install these systems, as well as to ensure compliance in the construction and installation of these systems. Dual licensure is an additional burden on the companies who have the installation experience for fire and smoke damper systems. Excuse me. I would assume to support these rules that the fire marshal will be obtaining the same licenses that they are asking the construction industry and the journeyman to obtain. The proposed rules go beyond the fire and smoke damper legislation and clearly go beyond the legislative scope of the definition for the fire marshal's authority as defined in New Mexico law. 59A 5215 states that the state fire marshals shall enact rules for fire prevention. There is no mention of the fire marshal having authority to enact rules for the installation of such systems. There has been a view that this initiative has been a union versus non-union issue. However, that is not correct. This is a safety issue. This is a construction industry issue that needs to have clear defined rules and understanding of the processes and the importance of the state fire marshal working with the construction industries division and the construction industry. I would ask that these rules be sent back with the directive that industry, the state fire marshal, and the appropriate state agencies work together to create rules in a partnership that is cohesive and productive. Thank you so much for allowing me to speak on this.
Great. Thank you, Rhonda. Appreciate your comments. All right, and the last commenter before I take a break here, Randy Trainer with Commercial Real Estate and Development Association. Randy, if you can go ahead and unmute yourself.
Yes, thank you. My name is Randy Trainer. I'm the registered lobbyist for NAIOP, the Commercial Real Estate Development Association, and also for the Apartment Association of New Mexico. Let me begin by stating that there is clearly a need for these rules. There is also a need for these rules to be clear and understandable. Comments and responses exchanged between the State Fire Marshal's Office and CID couldn't be more divergent. This divergence should be a red flag that there are significant differences between the two principles impacted by these rules. These differences should be fully resolved before proceeding. This divergence in positions between the comments presented by CID and the responses to those comments by the State Fire Marshal's Office is puzzling. I have come to believe that we're all talking about the same thing, hence that we're not all talking about the same thing, hence the extreme divergence in positions. Mr. Graham mentioned earlier the discussion of installation, and I guess I would refer to that as new construction. And I think if you read the comments from CID, they make sense if we're just talking about new construction. And if you read the State Fire Marshal's responses, they make sense if we're just talking about existing buildings. I believe that the conflict between these two principles is rooted in the current processes for inspecting existing buildings and new construction. If the State Fire Marshal intends these rules to apply to new construction, then there are some basic issues which CID addresses, which must be addressed. And he even noted those in the motion to terminate that was made in August. He says, item number 9, to engage in collaboration with CID, the State Fire Marshal Office needs additional time to determine and clarify roles and responsibilities regarding new construction projects involving fire dampers. On July 30th, a motion to terminate the rulemaking, in a motion to terminate rulemaking, the State Fire Marshal stated that they did not seek the input from the CID, construction worker organizations, local fire departments, or other stakeholders to hear and consider their concerns on the topic of fire dampers. The motion was to terminate the rulemaking proceedings until such time as they could work to resolve these differences and concerns. Industry supported that motion. The motion was denied. I have to ask, what is the point in proceeding with rules that are likely to be technically, procedurally, and fundamentally flawed? What is to be gained? I often ask my client, what's the goal? And the goal should be to implement Senate Bill 143 and provide the industry with a clear, understandable process. I respectfully request that these rules be terminated until such time as the State Fire Marshal's Office, CID, and industry can resolve the conflicts noted by public comment. That concludes my comments. Thank you.
Right. Thank you, Mr. Trainer. At this time, I am noting that it is 3:23. Let's go ahead and take a 10-minute recess. Just give everyone a chance to stand up, give the court reporter a chance to relax, and everyone to grab a drink of water or do. I think I have 12 more individuals scheduled to make comments still. So thank you for waiting. We will get to you in short order. Let's reconvene at 3:34. Thank you.
Marshall back in the day.
Okay, I have 3:34. Let me just check with my court reporter. Melissa, are you good to go?
I am.
All right, thank you. All right, it is 3:34. We are back on record, continuing the public commentary hearing. Next on the comment list, I have Brian Condit with New Mexico Building Trades. Brian, if you can go ahead and unmute yourself. Brian, are you available? I see you are on. Let me go ahead and unmute you. Brian, are you there? All right, I'm going to come back to Brian.
You got me.
You got it? Okay.
Oh, there
Go
I
ahead,
am.
Brian.
I'm sorry about that.
All good.
Thank you. Brian Condit, New Mexico Building and Construction Trades Council. We stand in opposition to these rules, the proposed rules as they're currently written. We view this as well beyond the authorization of the PRC and the State Fire Marshal's Office. Extremely concerning to us is the dual certification requirements. And it appears to be in response to the Senate Bill 143, which, if my memory serves me correctly, the PRC and State Fire Marshal's Office opposed vehemently. So we would recommend that this be set aside in an effort to resolve some of the conflicts. And I will condition my comments based on the other entities and the reasons for their opposition to the proposed regulation changed. Thank you.
Thank you, Brian. Next, I have Israel Gallegos from TNT Tech LLC. Israel, if you're there, go ahead and unmute.
I'd like to give my time over to Scott Cannon. I'm just more of a secretary than anything else. Thanks.
Sure.
Hello.
Go ahead, Scott.
Thank you, sir. A whole list of things to go through, but as I heard testimony from other people, changed my direction. I am opposed and to the proposed rule change. And I'd like to reference Senator Stewart, the legislator that proposed the mandate for the PRC. She wanted testing and inspection and installation according to installation of fire dampers. And it seems that the fire marshal's office and the PRC ran with that and tried to include dual certifications for installers. I think that that has way overstepped what the legislature proposed. And for that reason, I'd like to oppose it. Also, no one has brought up that this state has limited social distancing, and there is very little seats in my experience with PSI for testing at this point in time. So if you're going to move on with this, you're going to have a hard time getting, you might have a hard time getting people tested because of the current conditions, health conditions that in this state. I also would like to note that I don't think it's appropriate for an enforcement bureau to be taking on judicial and legislative rulemaking. I think that should be left to the industries, and they should just stick with the enforcement. Thank you.
Hey,
Can I
Scott,
get your last name?
yeah,
Scott
can you
Cannon.
state your full name, Scott? I've got multiple Scotts, so.
Scott Cannon, Cannon.
Thank you.
Thank you. And that brings me to the next Scott, Scott Chapman of Fire Safety Sales Company, Inc. Scott, go ahead and unmute.
I'm still pretty much new to this thing. I'm not sure if we oppose it or not. I agree with a lot of the comments that there's a lot of funny things going on in this state with poor inspectors and poor installers. And this might be the only way to fix it, but I don't know how it's going to work or how long it's going to take. And that's my only problem is it's going to take at least a year or two to get all these guys trained through NICET. My one guy that's going through NICET right now, he's been working on it for 6 months, and it just takes a lot of time. And that's about all I have to say.
Okay. Thank you, Scott. Oops. Thank you, Scott, for that. Next, I have Phil Trujillo from E&M International. Phil, if you're there, go ahead and unmute. And I am not seeing. I'm not seeing.
This is Aaron with AT Commercial. I just contacted him and let him know he's going to jump back on. He had to jump off for a second.
Okay, I will let's come back to him. Let's go ahead, and my next on the list is Don Kaufman. Don, if you could go ahead and unmute yourself.
I'm unmuted, I believe.
Okay.
Mr. Mueller. My name is Don Kaufman. I have owned and operated Kaufman Fire Protection in New Mexico since 1975. I am also a board member of American Fire Sprinkler Association and past chairman association. Kaufman Fire has been providing design and installation of fire protection systems in all sectors, including residential, government, and the private sector. The protection of and safety of individuals across the state is a priority of our company. Upon review of the proposed regulations published by the New Mexico Fire Marshals, I have several concerns regarding several of the requirements which I'm here to express today. As I stated previous, the protection and safety of individuals is my top concern. However, the proposed rules create a dual licensure situation that not only violates current state statutes, but also creates a confusion within the construction industry and does not enhance fire safety and protection. For example, the proposed rule requiring installers and installation technicians of water-based fire protection systems to hold both a valid New Mexico CID MS-13 and a valid NICEP Level 2 certification water-based system layout. That makes no sense because the qualification installers are not addressed by NFPA 13, and NICEP has no such certification for sprinkler systems. I would like to read in the record from Kevin Hall, PE, MSPE, the coordinator, engineer, technical services with American Fire Sprinkler Associated, dated September the 17th, 2020. This correspondence is reference to a question raised by authority having jurisdiction required sprinklers, installers, fitters to have NICEP certified. The qualifications of installers are not addressed by NFPA 13, and NICEP has no such certification for sprinkler systems. The National Institute for Certification and Engineering Technology provides several certifications in the field of fire protection. However, none of these certifications are associated with installation of sprinkler systems. NICEP offers the following certification programs for fire protection: fire alarm systems, inspection and testing of fire alarm systems, inspection and testing of water-based layouts, special hazard systems, and water-based systems layout. Where there are installation components in the fire and special hazard certifications, water-based system layout is a focus solely on the design process and is not the physical installation. End of letter. I'd also like to note the insurance requirements that PRC is proposing through the State Fire Marshal is $5 million. That's excessive for most people in this state. It's clear to me that there are several issues within the drafting of the proposed regulations. I strongly urge that the PRC to delay the adoption of proposed rules and ask that the relevant stakeholders have time and the appropriate experience to work on appropriate rules in response to the passage of Senate Bill 143, which required the PRC to issue rules regarding the inspection tests of fire, smoke dampers, and smoke control systems. Thank you, and that's the end of my comments.
Thank you very much, Don. Next, I have Jason Espinoza of KW Consulting LLC.
Presiding officer, I'm in the same office as Rhonda, and my computer has super low bandwidth when we're both on it. Is it okay if I just do it off her computer?
That's fine, Jason. Go ahead.
Thank you, Presiding Officer. My name is Jason Espinoza. I am speaking today on behalf of the Sheet Metal Contractors Association in New Mexico. The passage of Senate Bill 143, the PRC Fire Safety Standards, sponsored by Senate Majority Whip Mimi Stewart, was solely intended to require the New Mexico Public Regulation Commission to issue rules requiring the inspection and testing of fire and smoke dampers and smoke control systems in accordance with national fire protection standards. The statute stated that the rules shall require that, quote, inspection and testing be conducted by the state or political subdivision of the state with a fire and life safety enforcement program or other person possessing a fire life safety certification from a program accredited by the American National Standards Institute, ANSI. Second, the rules shall require the person conducting the inspection or test shall submit finding of noncompliance to the owner and to the state fire marshal. Additional requirements related to the installation of such fire protection systems are not mentioned, were not contemplated, and are not authorized under Senate Bill 143. However, a majority of the proposed rules in the proposed rules affect the requirements needed for certificates of fitness for installers and installing technicians related to water-based fire protection systems, fire alarm systems, special hazard systems, and the fire protection system technicians. Due to this misdirected focus on installers and installation technicians, it has unintentionally created a dual licensure situation, which is a violation of existing state law and runs counter to NMSAE 60-13-1.1 of the Construction Industries Licensing Act, which states it is the intent of the legislature that quote, there be eliminated and wasteful and inefficient administrative practices of dual licensing. Additionally, the dual licensure requirement of installers and installing technicians does not address the safety goal of Senate Bill 143, which sought to create clear and straightforward quality and competency requirements for the inspection of fire and smoke dampers and smoke control systems. However, the proposed regulations actually have the opposite effect by creating blurred lines of jurisdiction between state agencies and creates confusion among construction stakeholders, which was the exact opposite intention of Senate Bill 143. The Sheet Metal Contractors Association of New Mexico agrees with the motion to terminate rulemaking posted by the State Fire Marshal on July 30th that states that the State Fire Marshal Office did not consider the ramifications of enacting additional qualifications for licensed contractors, which has created a possible conflict with CID rules in the estimation of CID. Additionally, we agree with additional statements in the motion to terminate that the State Fire Marshal Office needs further time to research and report the necessity of specialized certification for fire protection contractors. Last, we again agree with another statement in that motion to terminate that it is in the best interest of the State Fire Marshal Office, the Construction Industries Division, and other interested persons to consult with each other prior to proceeding with the drafting of the rules to clarify roles and responsibilities of all stakeholders. We urge you to listen to the contractors impacted by the proposed rules, by the stakeholders empowered to enforce the proposed rules, and by the hardworking men and women on the ground carrying out the important task of testing and inspecting fire protection systems. Additionally, I just do want to add, it's been interesting during this whole, almost 2-hour conversation. Again, going back to the intent that Senator Stewart said at the start, the purpose was to ensure qualifications to the inspection of smoke, fire dampers, and smoke control systems. But a lot of the discussion today is focused on NICET, which is creating sort of a blurring of the lines between the trades. NICET has nothing to do with ensuring that smoke fire dampers are mechanically capable to work, to actuate. So we really want to get back to the focus of Senate Bill 143, and we urge the commission to terminate the rulemaking and engage in a collaborative policymaking process with all stakeholders to move forward and create rules that are focused on Senate Bill 143. Appreciate your time today. Thank you.
Thank you, Jason. I believe Phil Trujillo from E&M International is back online. Phil, if you could go ahead.
Good afternoon, gentlemen. I appreciate you coming back to me. Again, my name is Phil Trujillo. I'm with E&M International. We've been installing fire alarm and clean agent suppression systems for the last 20 years or so. I agree with the intent, but I believe several items need some slight tweaking. That will allow all of us to keep the public safety regarding life safety for all of our residents in mind. And that's basically what I've got.
All right. Thank you, Phil.
You're very welcome, sir. I appreciate you coming back to me.
No problem. Next on the list is Michael Vidal of PLTI Fire and Security. Michael, if you're available, go ahead and unmute.
Yeah, thank you for hearing me out. As you said, I'm Mike Vidal of PLTI. We've been in the installation of fire alarm systems in New Mexico for over 25 years, and I appreciate the opportunity to speak. I just wanted to say I support the amendment, although it's not perfect, and I do believe there are some things we probably need to look at and address. But I support it because the years I've spent in the field and the things that I've witnessed firsthand, the shoddy and dangerous installation has been performed by quote unquote licensed contractors. And I think we would agree that there has been a ton of licensed contractors, not a whole lot of unlicensed work going on. But it's the ability of the licensed contractors that's in question here. The State Fire Marshal's Office and the AHJs around the state have been tasked with ensuring safe installations, safe practices, and inspection procedures. I think the state would be smart to listen to their representatives in the field. They're the ones out there who are witnessing the tremendous number of life safety violations, and they're telling us what needs to be done. And I think it would be wise to listen to what they have to say. Other than that, like I said, I would welcome opportunity to possibly tweak this a little bit, but I do support it. Thank you for allowing me to speak.
Thank you, Michael. Next, I have Andrew Vieja from Western States Fire Protection. Andrew, go ahead and unmute.
Good afternoon. Thank you, Presiding Officer Miller. I'm Andrew Vieja, Service Manager for Western States Fire Protection. I would like to thank the State Fire Marshal for putting the time into addressing the current fire protection requirements in the great state of New Mexico. I feel there is a need to update our requirements on the installation, inspection, and service of life safety systems. My concern with the proposed changes are the economic impact that will cause our industry. What research was done on how will this impact our industry from business, employees, and what were the results? New Mexico is not a business-friendly state, and more stringent requirements will discourage businesses from opening and relocating to our state. The new requirements will cause an increase in labor costs. How many individuals will be out of work because of the additional requirements is the question. It is also extremely hard to find individuals that want to join the life safety workforce, and this will put a burden on our workforce requirement efforts in and out of state. I looked up NICET level 2 certifications in other states, which is available on their website. Example, a larger state like California only has 41 inspection and testing certificates, 17 inspection and testing and fire alarm. All 50 states only have a combined 245 in testing and fire alarm alone. There are multiple other certification individuals hold, but more than half of the certifications are in fire alarm systems, not other certifications. My current Western States Fire Protection approximately has 30 fitters, inspectors, and alarm technicians. That's just a few less than California alone, inspections and testing certifications. It looks like NYSERDA's going to profit from this requirement proposed. We also have an issue with the current pandemic. There are travel restrictions, in-class training restrictions, and online options that might not be available to employees trying to get certifications. This will put a financial burden on individuals that are trying to cover the cost for their exam and training. CID has licenses in place that the state currently recognizes, which are the MS-12, MS-14, MS-10, E03, and others. The individuals must complete various on-site working hours and an apprenticeship program to receive these licenses. To add additional requirements currently is going to be extremely difficult to our industry. I asked to table the new requirements and address when our economy is in a better state and restrictions are lifted. I want to thank everybody for their time and consideration on how these new requirements will affect our industry. Thank you.
Great. Thank you, Andrew. Next, I have Fred Bazin, pardon me if I mispronounced that, from Western States Fire Protection. Fred, go ahead and unmute.
Good afternoon, everybody, and thank you for allowing me this platform to voice my opinions regarding the rules pertaining to the change in the fire and smoke damper ruling. My name is Fred Bazan. I'm the area manager for Western States Fire Protection. Western States Fire Protection has been in the fire protection industry in the state of New Mexico for 26 years now. Our motto is protecting lives and property, and we believe that very strongly. I would like to begin by stating I feel the direction that the New Mexico State Fire Marshal is taking to address qualified personnel and technicians is greatly required, but we also need to think about how this affects not only the industry, the technicians, and the employers, but the state of New Mexico as well. Our technicians here at Western States Fire Protection and many fire protection companies in the state of New Mexico and the metro area begin their careers through a federally funded or federally recognized or state recognized apprentice program. These apprentice programs consist between a 4 and 5 year period. That means that our technicians are going through 8,000 to 10,000 hours worth of online, on the job, correspondence, training, and code knowledge. Once a journeyman certification is achieved through these apprentice programs, it is up to the employer to recognize that these employees need to get their New Mexico journeyman's 12J certification and license. I would believe that over 10,000 hours worth of on-the-job training, code knowledge, and correspondence qualifies those technicians to not only be a journeyman certified sprinkler fitter, but also to install fire sprinkler systems, along with having the New Mexico 12J certification license. With the qualifications of these certifications as a journeyman sprinkler fitter, we are asking that the state fire marshal recognize or add in and/or language to recognize that these technicians have not only finished with a qualified apprentice program, but also got their New Mexico State regulated journeyman's license. We would also like to have the state recognize right now that we are currently in a pandemic. And with the pandemic, we have seen the slowdown of revenue projections within the state. The construction industry is a frontline employer right now. And with us being a frontline employer, adding certifications, adding extra costs to a technician and extra costs to an employer is not the time to be doing this. We also would like the state to recognize that we would like all parties to come to the table and come to an agreement that is agreeable to everybody that within the industry. And with that being said, Western States Fire Protection opposes the language being put forth now. Thank you.
Thank you, Fred. Next, I have Aaron Oregon from ADT Fire Safety. Aaron, if you're there, go ahead and unmute. Okay, looks like he might be indisposed right now. Yeah, he's indicating he's on a call. So I'll come back to him. Let me see, I've got two more people left. Jim Oswald, architect. Jim, are you still with us? Okay, I'm not seeing a listing for him. Let's move to Jennifer Penner of Studio Southwest Architects. Jennifer, go ahead.
Hello, thank you, Presiding Officer Mueller, members of the Commission, Senator Stewart, and participants for this opportunity to offer public comment. I'd also like to thank the State Fire Marshal's Office for their diligence in maintaining an exemplary level of integrity and fortitude in upholding the life safety and public welfare in their charge. My name is Jennifer Penner. I am the 2020 AIA New Mexico President, and this matter was brought to our attention for our position as it is relevant to our membership and industry counterparts. In our 2020 legislative agenda, AIA New Mexico states that we support relevant boards and commissions in conjunction with the New Mexico Regulation and Licensing Department as the appropriate entities to address suggested modifications to the scope of professional services that may affect architects, engineers, surveyors, landscape architects, and others in the design industry. We took this position because it basically acts as a catch-all to assert that we support RLD and CID as the appropriate body to oversee regular and granular rulemaking, modifications, and management as intended and granted by the New Mexico legislature. We agree with the Construction Industries Division statement, wherein they expressed that no licensing or certification be made through statute, but rather through the authority granted by the legislature to CID. This is important because it establishes order and is the sole charge of the Construction Industries Licensing Act, which was enacted by law in 1967. As was brought forward earlier, we also support retaining language regarding engineering. Again, thank you for this opportunity to provide public comment.
All right, thank you, Jennifer. Let me just check. All right, the last two people signed up were Jim Oswald and Aaron Oregon. Let me just check with Aaron if he is available. Well, I'm waiting for his response. Isaac, was Jim Oswald, did he enter in at some point and is no longer on, or?
I did not see him enter.
with his name. There are a couple phone numbers that showed up and then disappeared that I did not recognize. So it's possible he called in at one point and then had to disconnect. I don't see anyone with that name who's ever connected. It looks like Aaron says that he is still on a call, so he's not going to be available.
Okay, yeah, Aaron indicates that he'll have to defer. He is still on the call. If he becomes available during time for responses, I will come back to him. Currently, that is Isaac, I believe that is everyone that I have signed up for commentary. Is there anyone currently on that feels they were skipped or should have been allotted or for some reason wasn't on the list provided? Go ahead and make a comment now. Okay, then I think we have reached the end of our preliminary comments with the exception of Aaron Oregon and Jim Oswald. So what I'll do is, well, first of all, I'd like to correct a previous statement on the record when I indicated that there was not a commissioner present. Commissioner Espinoza has been on this call and remains on the call right now. So I just would like to correct my statement from before.
Thank you, Hans, because I did hear that snide, disrespectful remark, and I really appreciate it because this situation as dampers has been very important to me, and many of the fire marshals know that I have been there for this discussion throughout my term, and I've been very engaged. So I just wanted to make sure that, yes, you understood. When I initially logged on, it sounded like you're having problems with people or unmuting them or muting them. And so there has been a delay, but for the record, I just want, as I mentioned in the public meeting this morning as well, since we've been on Zoom since 9 a.m., that I definitely have been participating. So I think it was maybe perhaps Rinaldi that had mentioned something, but I just wanted to correct the record, and thank you.
I believe it was during his comments when I made my remark, and I probably just did not, you might have been appearing as a phone number without the name next to it.
Yeah, my other phone is dead.
So I just wanted to correct that for the record, that you had been on the call here and listening to.
I sure appreciate it.
So
good.
rest
I
assured-
appreciate that. Yeah, I appreciate that, and I appreciate each and everyone's comments. And, you know, as we try to work in a unified manner, I appreciate everyone's participation, but mainly, you know, their comments. So we'll get to this. And so thank you, Hans, very, very much, and everyone who participated.
I'll open it up for response comments. This would be a time not to make additional comments that haven't been raised, but if you in particular wish to make a response comment to any of the comments presented, we will go ahead and do so. I'll limit that to 2 minutes each, depending on the number that we see. If you can go ahead and either, if you're familiar with the Zoom platform, either raise your hand or you can have the option of sending me a chat message indicating that you would like to make a response comment. I'll kind of, that's the only way I think I'll be able to sufficiently indicate comments. I see Mr. Rinaldi has his hand raised. Go ahead and make a response comment, Mr. Rinaldi.
Thank you, Mr. Presiding Officer. And I would like to make a clarification for Commissioner Espinoza. That was not in any way, shape, fashion, or form a snide remark or disrespectful in any way with regards to you not being in the meeting. This is a very important topic for everyone that deals with life safety in the state of New Mexico. And I appreciate you being present in the meeting. And I was simply hoping that these comments would be relayed to the commissioners so that they could use them and in an informed way in making their decisions with regards to this rulemaking process. I'd also like to step back onto some of the comments and clarification with regards to some of the comments that have been made today. There's a lot of different organizations that are represented here, plus labor unions and individual contractors. This is a critical situation for New Mexico with regards to, we have, thanks to the senator, this was put through with regards to state legislature, has moved it forward. It is in the state statutes. It's a requirement now, and the rulemaking process to take care of the issue about the certification of those that are doing the certification of these systems is important. But I think that based on the documentation that was presented for the rulemaking process, there's just, it's overstepping with regards to the state fire marshal's authority. And I think that going back to what Jason had mentioned, is that we really need a collaborative rulemaking process involved with this that is bringing everyone to the table, sitting down. And I don't think that this particular rule was done in that fashion. And I would implore that the commission take consideration of that and slow this process down, not push this rulemaking through, and bring it back to the table so that everyone, as far as the stakeholders involved, can have the opportunity to work collaboratively to come back and present something that is not going to find as much opposition as this is, as you're seeing today. And with that, I'll yield, Mr. Presiding Officer, and thank you for the opportunity.
Thank you.
Mr. Hearing Exam Officer, this is Commissioner Espinosa, and I would just want to thank Mr. Rinaldi for the clarification and for your comment.
Okay. Thank you, Commissioner Espinosa. And yeah, I will second that. I apologize for the miscommunication I had in implying that a commissioner wasn't on the phone at the time. So adding to that miscommunication. Next up for response comments is Mr. Montoya. Lawrence, go ahead and unmute yourself.
Thank you, Presiding Officer Mueller. So in hearing a lot of the responses from other individuals, I think it's imperative that our office provide a response. Well, first and foremost, our office has been in existence for over 3 decades. And in that time frame, we've had the Certificate of Fitness program that's been existent and has been compliant with most contractors throughout the state working on fire protection systems. I find it ironic today that many of these contractors are in disagreement with the understanding that they have to already meet a minimum requirement in order to obtain a certificate of fitness, which permits them to work on fire protection systems in the state of New Mexico. I find it further ironic that they feel that now that there's been some modifications to the change to the rules, that they feel that we're pulling something out of the air. So I just want to make it a point of record that the Certificate of Fitness program has been well in existence within the State Fire Marshal's Office, requiring competency levels to be provided. Now, the way that the rule is currently written, it's very subjective. It says you have to have proof of documentation of training. And the thing is, some people take 4-hour classes online. There's no way to prove that that person even took the course. The level of integrity between knowing who took the qualifications of the test, it's almost impossible. Now, it makes no sense for us to regulate the fire and smoke dampers, which are a very small piece of the pie. If we look at the big picture and we can make the relation between, say, a battery in a car, that's what smoke dampers and fire dampers are to a fire protection system. It's just a very small piece of the pie. So for us to require more regulation on a person wishing to inspect a fire or smoke damper than those who are performing the installation or inspection or testing maintenance of complete fire protection systems, that would be almost close to ludicrous why we would have that. Now, the changes that took place are only going to better New Mexico. Now, I find it quite ironic that there's a lot of contractors that don't agree because they say that it's going to cause an economic impact. And I think that conversely, this is going to help not only fire protection contractors or for those people like the sheet metal union workers who made it a point to state that this was a way to obtain more revenue for their services. But when we have a list of 100 contractors and these people are not licensed, they're not qualified, they have no proof of education as it relates to fire protection systems other than their CID licenses. And many of these people do not have, or these contractors, they don't have any insurance coverage. Okay. Everybody on the call today has said, we support fire and life safety. We want to keep the public safe. Well, that's what the State Fire Marshal's Office is here for. It's to speak on behalf of the public that are not on this call and then to ensure their safety, regardless of the amount of money that the people wish to make off of their safety. But it's disheartening that the same people that are indicating that life safety and protecting the firefighters and protecting first responders is of their greatest interest, yet nobody here has said, or very little have said, excuse me, that they fully support their competency levels. And an MS-12, a GB-98, an MM-98, an MS-14 from CID, these are people that are working on regular plumbing on somebody's backyard, people who are working on low voltage electrical systems in your backyard or your front walkways. Yet these are the same people that we don't have to prove any competency level when it comes to a fire alarm system that's going to protect your kids every single day at school when you're not there, or when you watch
Lawrence, Lawrence, I will ask you to finish your commentary. I have allowed you to go over here.
Thank you, sir. So in closing, I just want to make it very known that we did reach out with New Mexico CID. CID indicated that they did not have a system to test for specifically fire protection systems, which is why we feel that we're covered in state law. For those reasons, we support the rule changes and we ask for that to be approved. Thank you, Presiding Officer.
Thank you. I have an indication from Aaron Oregon that he had to leave, so he will not be making comments. I have a question from if Mr. Brasher or Mr. Bohannon could repeat the citation in the red line where it strikes the word engineer. Mr. Brasher, Bohannon, if you're available still, could you kindly repeat the citation?
This is Paul Brasher. If you would repeat the question for me just a second.
Sure. Could you repeat the citation in the red line where it strikes the word engineer?
There's an entire paragraph that is deleted. It's paragraph C that within which is a subparagraph that refers to the Board of Licensure for Engineering. It's I think just a second. I'll get that.
If I may, this is Perry Valdez, the Executive Director. That section is 10.25.5.2 section where it deals with the scope, and that is section C, where it refers to CID, New Mexico Board of Engineers and Surveyors. And the proposed rules changes, it does not reflect that there was a strikeout of that language. It just refers to A, B, and a new C, but does not show the strikeout.
the entire paragraph, it refers to the Environmental Improvement Division and a couple of other references in it that they're just entirely, they're not redlined, they're not stricken out, they're just eliminated entirely. And so my point a minute ago was that they should not remove any references to the Board of Licensure for Engineers and Surveyors. Not speaking for any of the other boards or agencies that got removed with that elimination.
Okay, thank you. I think that answers that was posed to me there. I do not see anyone else has messaged me or has a hand up currently. So I believe that will conclude the public hearing commentary. I'd like to remind. Yes.
This is Kevin Graham from the RLD and CID. I did send you a message asking to respond briefly. I just wanted to. Thank you. I believe I must respond to Mr. Montoya's comments there regarding the CID's willingness to meet and talk with people. Director of CID, Clay Bailey, met 3 different times with staff from the Fire Marshal's office, had multiple discussions, and offered to meet again to discuss these concerns. Detailed legal comments and arguments were made to explain the legality issues of what was being done and the overlap with CID's authority and the contradiction of CID's authority. So if were comments to be made to imply that somehow CID didn't want to do this or didn't want to work with you or with the State Fire Marshal's office, those are simply inaccurate. And they are not supported by the facts. And the fact is, this is a legal issue that has to be addressed. The rules as proposed are in violation of law, and these rules should be withdrawn. People should go to the table, work out appropriate rules, and then come back and adopt the rules that are needed. So, thank you, sir.
Thank you. I think that leads into my next point that I was going to bring up, is just to remind everyone that the purpose of this hearing is to give interested persons an opportunity to give oral comments. But under the rules of the commission, that is simply what they are today. They are oral comments. As I indicated, Commissioner Espinoza has been listening to everyone's oral comments. However, these comments do not go on to the official record as evidence. If any party wishes to introduce official evidence onto the record, I would encourage you to file a motion to intervene in order to do so. So this is just a reminder of, the limitations of today's oral comments, that they do not become official parts of the record. So if you have questions on how to do the motion to intervene, contact our records department. The case number is 2105 FM for those that would wish to do so. If you feel that you would like to formally introduce evidence into the case. With that being said, I have a request from Isaiah Zemke for an additional point of clarification. Isaiah, go ahead.
Yes, I was just wanting a point of clarification from Chip Hollis with NICET. You said that NICET is not an ANSI accredited program?
That's correct.
Okay, thank you.
Okay. With that, I believe that concludes today's public hearing. I would like to thank everyone for taking the time to make the oral comments and expressing your concerns to the commission. This has been recorded, so I believe it will be accessible again on a YouTube link for those that want to review it. And as I indicated, for those that actually would like to formally become part of the record, the best route is to do a motion to intervene. But thank you everyone for bearing with us and staying here through the last 2.5 hours. I appreciate everyone's points that have been brought forth, and I look forward to proceeding with this with staff and the commission moving forward. with that, I thank everyone again and enjoy the rest of your afternoon.
Exceptional job, Hans.
Thank you, Commissioner.
Bye now.